Okay, so good afternoon, everybody. My name is Kristen, and I am one of the co-founders and chief executive for Human. Thank you so much for joining us today. We are here to talk about all things when culture goes to court, and we have two fantastic speakers today, which I'm actually going to get them to do something a little different and introduce themselves rather than me doing it because I'm convinced that I don't do justice to any of it. But before I do that, I would just like to acknowledge the traditional lands on which we all meet today and pay our respects to elders past, present, and emerging. So, with that, I would like to warmly welcome Ben Smith to the stage. Welcome, Ben. Thank you so much for joining us today for this webinar. Please tell us a little bit about you.
Yeah, sure. And thank you for inviting me to the stage. I look like I'm under the stage lights, actually. I was about to say I'm not generally this shiny in person, but I think I am, to be honest. So I am a senior associate. I'm a solicitor at Mello Olson Lawyers, which is a multi-practice commercial firm in the Adelaide CBD. I work exclusively in employment law, so employment law, industrial law, workers' compensation, if we have to, which we often do. Considering the themes that we're discussing today. I've been at Miller Olson for about 3.5 years now, working exclusively for employers and the odd chief executive. Before Miller Olson, I worked at a firm called Tyndall Gask Bentley Lawyers for just shy of 7 years. I did not receive my pro rata long service leave, and I generally acted for sort of a mix of employees and employers, again in the same areas of employment law and workers' compensation. So I'm very niche. This is the only area of law that I know about. I love it. It's fun to an extent. It can be dry at times, but generally there's those elements of drama and intrigue that you may see in criminal or family law matters without the risk of someone going to jail or losing access to their kids. So generally the stakes are a lot lower, which I'm much more comfortable with. But this area of law is just constantly expanding. So it's an exciting time to work in this area. It's probably also a very stressful time to work in this area. So it is important that we all keep ourselves updated. So thank you both for inviting me along. And I'm sorry I've introduced myself for so long.
No, fantastic. Thank you so much, Ben. And you're right. I think it's actually a growing field at the moment. So we'll
Mm.
dig into that in a little minute. But then also I would like to welcome Sam Young to the stage. So Sam is my other co-founder of Human, and Sam is a clinical psychologist. However, I'm going to actually get Sam to introduce herself to us as well and tell us a little bit about you, Sam.
Thank you, Kristen. Can I just also add about Ben that he was the rising star for Doyle's 2025 employment and WHS law, and he's so humble he didn't mention that, so I just felt I needed to. Congratulations, Ben.
I'd rather everyone think I'm not up myself compared with, yeah. So thank you for that. I appreciate it.
Of course. So I am Chief Health Officer for Human. Prior to joining Human back in, wow, it was 1st of April, Fool's Day that we launched, Kristen. I was CEO and founder of Human Psychology, which is still Adelaide's largest provider of psychological services, mostly in the employee assistance program, clinical counselling space. So I'm super excited and grateful to now be working in the more preventative systemic space with psychosocial safety consulting all the way through to certification against the human standard. And yeah, we're having a very busy but amazing time working together, Kristen and I. And we're going to talk about when culture goes to court today, Kristen.
We are. So, really, this session's all around unpacking recent precedent cases from court services like Vision Australia. There's the stuff in WA and a whole bunch of other things that we're going to be talking about. And what we're really looking to explore, as you can see on the screen today, is what actually went wrong, what the law really now requires, and also what leaders and boards need to think about when they are protecting both their people and also their organisations, because now things are really starting to dial up in regards to what we need to be thinking about as business owners directors, senior leaders, HR, work health and safety people. So today we're really going to be unpacking some really interesting case studies of what not to do, because culture, as it says, isn't just a value, it's actually a compliance issue now. So with that, what I would like to do is, I guess, head into some questions. And so, Ben, I'd like to start with you just around the Court Services Victoria model, or that had the huge fine, the 380K fine, to think about what actually made this case significant.
I think most of these sorts of cases generally have a common theme that there's a person in a role who silently suffers from psychosocial risks or hazards. And it's only once the person breaks down and goes to see their GP and gets a medical certificate and never returns to work that the employer becomes aware of, oh, wow, actually, this person was being affected by the work that they do, and maybe we should have jumped in earlier and done something about it. The Court Services Victoria decision, which involved a solicitor actually, employed with the Office of Public Prosecutions in the Specialist Sexual Offences Unit. So this was a person who was clearly going to be exposed to significant trauma every day she went to work. So much so that the unit had a vicarious trauma policy. They were aware of this risk of vicarious trauma. The issue was that despite this apparently quite comprehensive policy, which referred to vicarious trauma as being an unavoidable consequence of the work that this solicitor was doing, it didn't seem that the unit, or I should say the Office of Public Prosecutions, the OPP, went to much effort in actually following the policy and making sure that they were doing what the policy required them to do. So it was a bit unusual in the sense that we had a government entity responsible for dealing with quite serious sexual offences who failed quite miserably, it seems, in actually protecting their employees from these harms that everyone was aware of. And I mean, the decision sort of unpacks the chronology of this young solicitor identifying that she was having issues with the work that she was doing and raising concerns, and even getting to the point where she was one of a number of staff who signed a memorandum about the significant workload and the inherent stresses of the role. But all of that was seemingly ignored by the OPP, and as you've said, Kristen, it led to a very significant fine following a prosecution. So it was a little unusual in the sense that you'd think that an organisation like the OPP in Victoria would be well aware of these risks and have processes in place that they rely on to manage those risks, but they failed to do so.
It's really frightening, isn't it? I think, there's a lot of organisations out there that have policies and procedures. Most of them do. And it would be really interesting to go through and actually do a bit of an audit or a spot check to understand which of those policies and procedures are actually current and up to date, and which ones people actually know about and how to follow them. I think it's a really interesting warning for people that if they've got them, make sure that they were aware of them and know how to actually follow them properly.
Even having an adherence to policy might be a solution. But making sure that the middle managers and the people who are actually responsible for interacting with the people at the coalface, that's a massive part of it. So making sure that those policies are regularly communicated and shared and followed.
Thank you. And we hear a lot about organisations now under the under the Act, Work Health and Safety Act, where they need to be making sure that they're minimising risk to as far as reasonably practicable, which is a really easy term to say, let alone do. Are you able to give us a little bit more in regards to what that reasonably practicable actually means?
I can, in one sense. The answer really to that question, I think, is it depends, which, if you've ever dealt with lawyers before, is a phrase we often use both seriously and in jest to really highlight that it's fact specific. It will depend on the individual circumstances of any specific case. So importantly, it will depend on the industry within which the employer operates. It will depend on the specific nature of the duties performed by the employee and the potential risks that they might be exposed to. So I think to get to the answer of what is reasonably practicable for our organisation to implement, it really does require a deep understanding of those psychosocial hazards that are present for your employees. So it probably does require collaboration across departments and sections of a business if it is a larger business that you're dealing with. Yeah, the question of reasonably practicable is hard to define in the absence of facts specific to a set of circumstances. But really, it's about identifying the risks and figuring out how can we make this easier? How can we make this better? How can we lessen the impact of this risk? So that's much easier to do if you do have a comprehensive understanding of what your business does and what your employees are required to do. You can then identify what those risks are and see if there are any steps that the business can take, which may not be overly onerous, to then consider whether that might be reasonably practicable in the circumstances and to determine whether any further action is necessary over and above that.
Yeah, great. Thank you. Sam, this is on to you. And we obviously heard just before about vicarious trauma. So I'm actually going to start with that one. Are you able to give us just a really high level around what vicarious trauma is for those people that are actually watching this webinar today?
Yeah, absolutely. So, vicarious trauma is being exposed in your job to traumatic content or events. So it could be reading, hearing, witnessing, traumatic exposure. So that could be anything from first responders, obviously your paramedics and fireys and police officers, through to emergency departments, social workers in child protection. But even, in say your work, Ben, a paralegal reading a transcript from a court document, that could be deemed as vicarious trauma. So it's not happening to you directly personally. That's primary trauma. It's when you've vicariously experienced it.
Yeah, thank you. I just thought that it was helpful to
Yeah.
what that was. And staying with you, Sam, so why do you feel that leaders are kind of really missing the visible distress signals that are taking place?
Just looking at this list, I think it's interesting, Kristen, because each precedent, even though they're really different, tells the same story. Like the warning signs were visible, but kind of ignored. So different sectors, same pattern. And whilst hindsight's perfect, I know, foreseeable risk, inadequate control, and kind of preventable harm as a result. So I think particularly in occupations where there is a high risk of vicarious trauma exposure, there tends to be a normalisation of it, that it's just the job, and almost sometimes a culture of weakness associated with having a normal human reaction to what we would define as abnormal human events. So, like, it's not normal for someone to go to work and witness death and terrible injury on a daily basis. Like, that's not normal in the sense of a normal human experience. So, I think vicarious trauma is a normal human reaction to abnormal circumstances, and often high performance becomes normalized and then distress becomes invisible. So people just suffer quietly, and they're labelled as resilient. So it's seen as being resilient, not risk. And so I think leaders need to get a lot more curious about changes in, mood, output, or presence, not just results, and also think about whether we are normalising occupational harm as something that's just expected as part of the job. And if you can't hack it, then you need to get out, kind of feeling.
I think a similar analogy is probably relevant in our industry, the legal industry, that there's certain areas which might attract vicarious trauma, but I think that the best analogy for what you've just said, Samantha, is that older senior partners expect junior lawyers to get in at 8 o'clock and leave at 8 o'clock, work as many hours as possible. And for some people, they thrive under those circumstances, and they love it, and the law is their life. For those with varied interests like myself, I couldn't hack that. I couldn't handle being required to work 12 hours a day every day, and have my life as being solely my job. So I think it does raise a good point that every individual is different. So while you can have these policies and processes in place to make sure that you're identifying these hazards, it may be that some employees are, like you've said, Samantha, more resilient than others, or work better under certain conditions. So it is a fine line in circumstances where historically, people had to work their butts off in order to prove themselves and understand the role they're doing and continue in that field. So it is a fine line, I think, between performance and resilience. And it just makes it so difficult for employers who not only want to get the best out of their employees, but want their employees to be in the best headspace possible. It is difficult.
Yeah.
Really interesting. I've just been doing some work with another client, and they work in a really high pressure place, and they have basically a high performance motto. And it's really interesting to talk to a lot of the staff. I'm doing a bit of research at the minute and hearing how they all feel like they're in a marathon, but they're actually constantly sprinting. And so what that's doing to the turnover is quite significant within that business. So yeah, it's a really interesting concept. Which kind of, I guess, leads me to my next question, and that is around how can culture act as a control measure?
Yeah. So I think the way we see it at Human, Kristen, is compliance is the floor. It's not so compliance is the floor and culture's the ceiling. So culture's what sets the behavioural norms of how work really is done, how we do things around here, whether people speak up, whether people support each other, or whether they suffer in silence. So, a healthy culture is actually a preventative control, not just a great thing for the humans in the business, and because it protects people before harm occurs. So, yeah, I think culture is probably one of the most powerful control measures that organisations need to think about.
Yeah, definitely.
Well, and particularly when employees seem so resistant to raise concerns about suffering at work. I know that there are certain partners out there at law firms that I would never say a word to about work-related stress because I know it would be detrimental to my career. So you're absolutely right. That culture is so important to have your employees feeling safe enough to raise concerns so you can deal with it before it becomes a bigger issue.
Yeah, definitely. I want to move on to the Department of Justice WA, where they saw their first prosecution under the new work health and safety laws, Ben. What message is the regulator sending with this one?
I think the safe work inspectors are enjoying the seeming expansion of their powers. And I think it just demonstrates that the regulators in each state that they may take this stuff very seriously. We've seen, not to this extent in terms of actually proceedings being commenced against employers, but we're certainly seeing a lot more compliance notices issued in South Australia. We act for a number of state government clients and local government clients. With employees who obviously have unions behind them. They're unhappy with certain parts of work and they're effectively using the reporting process through Safe Work, in my opinion at least, as a vehicle to agitate these issues in the workplace. So rather than it being an email to the manager and a meeting down the line and a further meeting in 6 months, they're bringing it all to a head as soon as possible because, the CEO of the business receives a letter from Safe Work saying, you have to comply with this within 21 days or whatever it might be. It certainly makes things a lot more serious, a lot more quickly. So I think the Department of Justice proceedings in WA just demonstrate that the regulators, they are willing to go to that next step from the compliance notice, that if you don't comply with that they will take action against you. And we're seeing it a lot more with fair work inspectors as well on the other side of things in terms of contraventions of awards and enterprise agreements. So Yeah, I think the regulators are stepping things up, which is good considering I think some of the heat that other regulators in the country have been copping for being effectively toothless tigers. So, on the
Mm.
one hand, it is stressful for employers who face these compliance notices, but I suppose on the whole, from a social point of view, it
Mm.
probably is a good thing that the regulators are actually using their powers rather than just, sort of threatening to use
Mm.
them.
Yeah, it's
And I
interesting.
think I was going to say, Chris, and what's interesting here,
Yeah.
so the case was a correctional services officer who alleged bullying, sexual harassment, and victimisation from her role in a prison. And whilst they've dropped the case for now, there's still a civil case proceeding by the employee. So, yeah, even though it's been unexpectedly dropped at this stage, this second prosecution, the case still hasn't been dropped by the employee from a civil point of view.
Yeah, and it's interesting, thinking about the younger generation will call these things out loudly and proudly, whereas I think you're right when Ben was saying earlier that partners in law firms and accounting firms and engineering organizations and whatever, if you wanted to become a partner, there was an expectation that you would do a minimum of 12 hours a day and work really hard.
Yeah.
Whereas now we're seeing a generation of people that are not prepared to walk past ordinary behavior, and they will call it out. So we're looking at a very different landscape, I think, these days too, which yeah, is really really interesting. Question again for you, Ben. What
Yeah, of
actually
course.
constitutes systemic failure? So if we think about this one, that's the Department of Justice. What constitutes that being a systemic failure? Do you think?
I think broadly it's really just a failure to follow your own processes. So clearly, the Department of Justice in WA were aware of these issues, and obviously that was the basis for the proceedings, that they'd failed to provide a safe work environment for this former prison officer, or was a prison officer at the time, obviously. Um, but it really just does demonstrate that it's not just private companies that need to be aware of these risks, these obligations that they hold, and that the government is prepared to turn on its own, so to speak. And like I said, we are just seeing a lot more compliance notices being issued and a lot more anonymised complaints by presumably employees to the regulator, which seems to bring these issues to a head sooner rather than later, which, to be honest with you, may not be a bad thing in some cases, despite the stress of the HR personnel. It may ultimately be a good thing on the whole, but we obviously need to be careful that we're complying with our obligations and not putting ourselves in a position where we may face pretty significant fines and penalties for breaching these laws.
Yeah, absolutely. Sam, this one's for you. What's the link between organisational justice and safety?
I think if people don't trust the system in place in the organisation, so if they believe complaints will be ignored or punished, then trust basically collapses and then you see harm compounding. So, psychological safety depends on fairness, fair process, fair treatment, fair leadership. And I think this case really strengthens the trend towards workplace mental health policies becoming mandatory, right? Proactive management of psychosocial hazards. So it's not just the firm legal accountability, it's comprehensive risk management, procedural fairness and transparency, early intervention and support integration, and active monitoring and reporting. And just running some workshops or the compulsory online module on bullying and harassment just doesn't cut it anymore.
It's a bit like the mental health, what do they call them? Mental health first aiders.
Yeah,
Yeah, we're
it's
hearing a lot.
nice.
Yeah.
It's nice, but that's only a minor component of a reactive control in the whole spectrum of hazard controls that organisations should be looking at.
Yeah. I'm going to move on to another case. So this is the Office of Public Prosecutions in Victoria. So it was the Kozarov case. How did the High Court change the onus of responsibility on this one, Ben?
I think I might have already discussed this case. Sorry, I may have
Have
gotten it
you?
confused with the court services.
Yeah, that's right. We can skip that one. Let's go to the
Yeah,
big one.
so
Let's go to
Okay,
vision
let's
because
tackle
that's the
vision.
big dollars.
the
All
big
righty.
one.
This is the Alicia case, right?
Yeah.
Yeah.
Yes.
Okay. So, do you want to give us a bit of a rundown on what this case actually was, or do you want me to do it? What would you prefer to do here?
I'm happy for you to provide your rundown, and I can supplement it if you like. Yeah.
Yeah. So, in this particular one, there was a staff member who was being managed for poor behaviours in the workplace. The staff member subsequently was terminated, so investigated and terminated. And the staff member then applied for unfair dismissal and was awarded a minimal amount. I think it was 27,000 or something like along those lines.
I think the worker actually signed a deed
There you
to
go.
settle the unfair dismissal
Right.
claim. Yeah.
Yep. 27 grand or
Right.
whatever it
Yeah, I
was.
think that's right.
Yep. And basically, what then happened because of the way that the organisation handled the investigation and dealt with all of their policies and procedures, the person then claimed that injured them psychologically, and so they then proceeded to sue for damages and were awarded $1.4 million, which is a significant amount of money. And I think it's kind of set precedent. How did I do, Ben? Did I do okay?
You did very well, very well. And so thank you for giving the summary. So yeah, you're right. It was a massive amount of money. Not an unusual figure to see, I suppose, in negligence claims generally, which was one of the causes of action upon which Mr. Alicia pursued Vision Australia. But the High Court ultimately found that it was a breach of contract. They found that the contract essentially incorporated the employer's policies, such that a breach of the policies was therefore a breach of the contract, meaning that Mr. Alicia could sue Vision Australia for damages arising from the breach of contract. The settlement of the unfair dismissal proceedings was quite interesting. Apparently, the way in which the settlement agreement was drafted did not stop Mr. Alicia, obviously, from pursuing subsequent claims against Vision Australia. And apparently it was simply because the settlement agreement referred to resolving any and all claims arising out of the employment and the termination, as in any claims that arose from both of those things, the termination of his employment and his employment, he was stopped from pursuing. And the High Court essentially found that, well, this isn't a claim arising out of his employment and his termination. It's about the fact that they didn't follow these policies and procedures, which are incorporated into his employment contract. So the court did well at getting Mr. Alicia through on that point, and ultimately, compared with an unfair dismissal claim where your remedy is restricted to reinstatement at an absolute worst case or 6 months' wages, and in a very common sense way, the Fair Work Commission would deal with that. It's essentially uncapped when you get to the point of a breach of contract or suing for a breach of any tort. So we are seeing here and there these quite significant claims and significant payouts, to use some American terminology, in circumstances where we really haven't seen that before. There was a couple of years ago a claim made under the age discrimination laws, and the worker was successful in claiming that the employer chose not to employ him because of his age, and he received quite a decent compensation payout as well. So we are seeing more and more employees with significant impacts from the psychosocial hazards of their work, going down the hard path. That's what this is. I mean, it would have been a hell of a lot easier for Mr. Alicia to make a workers' comp claim, sit on the system for a couple of years, hopefully rehabilitate and get some treatment and return to work in some capacity. But clearly, the impact of Vision Australia's failure to follow those policies led to significant issues for Mr. Alicia. I mean, you don't just receive $1.4 million in compensation without there being some basis to show that your life has been severely negatively impacted as a result of work. So I can tell you that since that decision's been handed down, I've seen so many articles on it from law firms. There have been so many CPD continuing professional development seminars held on the decision. So, plaintiff lawyers, employee lawyers are very aware of these decisions. And while I'd like to think that most of them would find it too difficult to go down that path, there will be these sorts of claims in the future. So it really is, it used to be that if you screwed up a disciplinary process or a dismissal, that, absent a general protections claim, you just had the unfair dismissal process to worry about, and you could knock it over with a few weeks' pay and, and a statement of service and maybe a reference. But yeah, in light of some of these decisions, if the impact is significant, then it may not be so easy for employers to get out of it.
What about the fact that they included in the contract the policies? I think that's a really interesting one, because you do see that where some organisations do have them included in the employment contract. Did you just want to elaborate a little bit more on that, Ben, at all?
Yeah, and every employment contract I've ever seen is that it says you are required to adhere to the employer's policies and procedures as are enforced from time to time, and are communicated to you. I think, and I probably need to go back to the decision and read it some more. It is long and it is boring, for lack of a more appropriate word. But the contract had a clause which essentially stated that there were other terms and conditions that applied to this person's employment, and the contract stated that that would be in accordance with Vision Australia's policies and procedures amended from time to time. So I think there was perhaps a more significant focus in the contractual terms to those policies and procedures, rather than more of an offhand, reference to the requirement to adhere to those. So it does raise some red flags for employers, and it is an important time to review employment contracts to make sure that, as far as possible, you've removed that risk of the a court determining that your policies and procedures are a contractual term.
Yeah, thank you. That's kind of what I was getting at, because I think as an HR person myself, I know not to have them in it. So I think that's the thing, isn't it? Is making sure that if you've got these employment contracts that have got that in, it's a good opportunity to go back and just review what your employment contracts are.
That's right. And the reason historically that policies and procedures aren't incorporated into contracts is that obviously employers want to avoid a situation where employees rely on the terms of a policy or procedure to for whatever end that they're interested in. So it is a fine line. And it is difficult, but it is very important that employers are aware of the risk.
Yeah, fantastic. Thank you. What is foreseeable harm? I know that was mentioned in this particular case.
Is that a question for me or Samantha? Sorry.
Well, Sam can
It's
answer.
definitely, no, I'm not the lawyer here.
I was just going to say, you can have a crack, Sam. Go for it.
I can have a go.
Oh, look, the frustrating thing about these reasonable and, a reasonable person or reasonable action or reasonably foreseeable or reasonably practicable is that, again, it just requires a deep understanding of your own business and the hazards that may present themselves in your workplace. So it is work. It does require a deep dive into the elements of the business that may present those psychosocial hazards. So again, it's about not just trotting out some policy we've downloaded from Google and whacked our letterhead on. It's about making sure that those policies are actually fit for purpose. And that when things do arise where the policy has some work to do, that the powers that be and the people who are actually meant to implement those decisions and those actions in the workplace are aware that they need to go back to the policy and strictly adhere to it. So it is, again, a difficult question to answer. And I suppose that'd be a good point to make that these hearings before the High Court, the federal courts, the Fair Work Commission, often they will hinge on the employer's interpretation of what might have been reasonably foreseeable or reasonably practicable versus the employee's interpretation of that, dependent on the circumstances. So overall, I think the main point is that it's difficult to understand what is reasonable in the circumstances if you don't understand your business. So that's the most important thing.
Thank you. Sam, okay, this one is for you. What can leaders learn from this case?
I think there's a couple of things I took away. That disciplinary procedures, treat them as binding contractual obligations. They're not just mere guidelines. Failure to fully inform employees of all allegations and to follow agreed procedures can expose employers to damage. And I guess this idea that fairness, transparency, compassion, they're not just kind of nice, they're actually risk controls in this situation. So the how of performance management matters as much as the what. So it's that classic reasonable management action has to be taken in a reasonable manner. So it's the how we go about it. Obviously, separating feedback from personal attack, ensuring procedural fairness, and offering wellbeing check-ins during conflict. So the goal is always dignity, not damage.
Yeah.
But yeah, I think adherence to processes now, binding, not optional, and psychological injury risk is a legal concern. So it's not about everyone backing away from performance conversations. And I think, Kristen, we're seeing that quite a bit with our client organisations, that managers are almost frozen or paralysed with fear of now talking about the work. And that certainly should have been the conclusion from this. It's about doing so with, respect, dignity, kindness, compassion, integrity, which we're hoping are characteristics leaders are all, working with anyway.
Some are. You and I both know that. So how do they integrate care into process? Because, we see with a lot of businesses that we go into that there are certainly people that have got leadership titles, for want of a better word, that potentially don't have the toolkit and or the training and or the experience to, I guess, really front into having these challenging / difficult conversations.
I mean, I think there's that classic, why are we promoting people? So we're promoting them on so-called performance and technical skills delivery, or are we also incorporating the so-called soft skills, which drives me insane, that term, but
Skills.
Thank you, essential skills. And are we actually then training people effectively, not just, a kind of cookie cutter cheesy workshop, but like proper leadership capability uplift? And are we valuing and rewarding the essential skills as much as the technical skills? So, I mean, I think a lot of the times we just chuck these poor managers into roles and, good luck. Off you go be a manager. And they've got no idea. So I think there's a training piece, again, back to culture, because, isn't it always back to culture? Is it safe for people to have conversations about the work? Because that's really how I see performance management conversations aren't at that punitive, pointy, formal end. It should start right back as informal coaching. We're just talking about the work, right? And we're separating out the person from the behaviour. So, has that answered the question?
Yeah, that's great. Thank you.
Cool.
Now I'm going to move on to two universities, Ben and Sam. So obviously there's been some interesting things happening in Australia in regards to a couple of our universities, one of them being UTS. So Ben, do you want to talk a little bit about what's taken place in regards to the change management piece at UTS and what the regulators' involvement in this one has meant?
Yeah, I actually tried to look into it a bit earlier today to see if there was more detail around the concerns raised with Safe Work, the basis on which they issued this prohibition notice to essentially stop UTS from doing what they were doing, but I couldn't find much about it, unfortunately. And whether that's due to Safe Work New South Wales privacy policy, or whether whether there's greater public policy reasoning at play, I'm not sure. But I do remember when the articles came out about, Safe Work has issued a prohibition notice. They've effectively stopped the University of Technology of Sydney. I don't know if that's the right name. I know it's UTS. Sorry, the media articles coming out saying that they had prohibited or stopped this redundancy process. My inbox was blowing up. I had friends in employment law messaging me saying, "Hey, can you believe this? Have you seen this?" My boss was absolutely irreparable. How dare this government organisation intrude on the university's plans to restructure its workforce? Because these were the sorts of normal views that people held, that sorry, it's a hard process and it's an unfortunate process, but it is what it is. A business is entitled to restructure its operations. And I've certainly acted for plenty of employers who have defended workers' compensation claims for psychological injuries that have arisen during a restructuring or a consultation process before a person's role is ultimately made redundant. So it was big news. It might not have seemed it for those who don't work in the area, but it really was, sort of almost a turn in the tides, just like the first matter that we were discussing. The Department of Justice matter that we were discussing, where Safe Work commenced proceedings against the Department of Justice. So it did seem to send shockwaves through the industry. It did seem to be quite short-lived. I believe they issued the prohibition notice on the 8th of September, and I believe it was lifted a few days later on the 10th. I might have those dates slightly wrong, but I understand it was a pretty brief period for which the notice was in effect. But again, it just does show that the regulators are, and I think more importantly, the Safe Work inspectors are emboldened by this sort of recent shift and focus on psychological concerns and psychosocial risks and hazards. I think 10 years ago, there would have been such a small focus on psychosocial hazards within the Safe Works around the country. And I think nowadays it may have flipped to a degree, that there may be more of a focus. There may be more inspectors out there looking into psychological issues, because we've probably gotten to a point in our modern society where we've done pretty well with physical safety, safe work processes and those sorts of things. But clearly, as evidenced by some of these quite big decisions, and based on at least what I've seen anecdotally in terms of a massive increase in psychological injury workers' compensation claims. And according to the Fair Work Commission president, in the last year, an increase of about 45% in general protections claims, which are, at least in my view, a more expensive unfair dismissal option. So we are seeing this big uptick in not only people taking action themselves for psychological issues, but the regulators stepping in to stop employers from doing what they normally do if they think there's a risk.
Yeah.
So, like I said, as I understand it, Safe Work New South Wales hasn't taken the matter any further. They are entitled to just continually check in. So while they may have withdrawn this prohibition notice, I have no doubt that they'd be in regular contact with UTS. So I suppose it still remains to be seen whether that process is concluded and whether there will be any proceedings that emanate from it.
And I guess it makes organisations stop and think now, doesn't it, more broadly about their change management programs and processes. If you're going into any form of change, making sure that you are coming through a lens of full staff consultation, because miss it at your peril. I think this is a really interesting case where, we all go through change. Gosh, I used to work for Big Four. It was a rotating desk policy there for a while. They had all of their computers strapped to desks and they'd move around rather than pick up all their stuff and move it. It was just much easier to wheel the desks around. That's what it used to happen. So
I think, at least until now, consultation processes have felt sort of perfunctory. It's a box ticking exercise. If your employees are covered by an award or an enterprise agreement, well, then you better consult with them. But again, send them a letter, have a meeting with them, make some notes, proceed with your decision. Or if they're award free, make sure that you've ticked the box of whether it was reasonable to redeploy them as required under the Fair Work Act. But other than a sort of cursory box ticking exercise of those processes, it seems that some employers at least I should say, don't take those processes too seriously. And to a degree that makes sense. I mean, the awards refer to when a definite decision has been made, or the wording changes depending on which award you're looking at. But, in circumstances where a business has made a definite decision, it sort of makes sense that unless you can identify a way to redeploy these people, then sorry, you're likely going to be made redundant. So in some cases, it makes sense that the consultation process is quick and it doesn't really achieve much. But I think this decision really just shows that it's no longer acceptable to just trot out the one-page letter that says, "Hi, you've been employed in this role. As a result of X, Y, and Z, it appears your role is going to be made redundant in 3 weeks."
Yeah.
So I think there just needs to be an elevation of the consideration of, if I was getting this letter and I've worked here for however long, how would I react? What supports would I want around me? How would I want this decision communicated to me? So I think it's just important for employers to be aware of the fact that someone can step in and make this process a hell of a lot more difficult if you don't consider those things from the outset. And I mean, you'd hate to see a situation where you're about to make, say, 10 people redundant and SafeWork comes in and puts a stop on it. And that's one issue. But the second issue might be that those 10 people are now buoyed by SafeWork saying, well, actually, this is unsafe. They will go to their doctor and their doctor says, you can't go back to work, you're too stressed. And you've got 10 workers' compensation claims, you've got 10 employees who may or may not come back to work. These things can become incredibly complicated without needing to be. So it is more than ever important for employers to get it right at the back end, as frustrating as it can be to do so.
Yeah, thank you. We have run out of time. We could talk to you.
I'm so sorry.
No. It's actually gone in a hot minute. So I'm going to say thank you. But before you both head off, I've got one final question and then we need to really wrap up. One thing leaders can do tomorrow in doing the right thing, protect themselves, psychosocial safety, one thing that you think leaders could do tomorrow.
Me first, I would say jump on the Safe Work Australia website and find as many codes of practice as you think might apply to you. Print them, download them, make sure they're handy in the workplace, and sit down with your managers and your leaders and your supervisors, and really get stuck into the detail and have a think about, well, what risks do we need to be aware of?
Yeah, fantastic. Sam, anything from you? One thing leaders can do tomorrow.
Start conversations about wellbeing at the leadership level. Ask what's the emotional climate of our team right now and how do we know this? What evidence do we have for this? And we need to stop seeing all of this as a burden or as a negative thing. It's like protecting wellbeing isn't a burden. It's good business and it's good humanity.
Awesome. Thank you. Thank you on behalf of Human. Would like to say thank you, Ben, for spending this time with us. And thank you to everybody that's dialed into the webinar today. It's great to see you and spend some time with you again today. This will be recorded and we'll be popping that up shortly. There's just a little highlight of what we actually get up to at Human. So if you would like...
And you can send us any questions you didn't get to ask, hello@human.global, and we're happy to try and answer them for you. So sorry we didn't get to that today. It's such an interesting topic.
It was.
Sorry, I've been rambling so much, everyone.
Not at all.
You're great, Ben.
Thank you, everybody. Have a fabulous rest of the week.
Thanks, everyone. Thanks, Ben. Thanks, Christian.
Cheers. See you guys.
Bye.